Good morning. After a long time, a case of murder uh, by gunshot murder, uh, conviction by lower court, high court as there are two accused. One was juvenile and for uh, causing disappearance of evidence. 201. High Court acquitted the juvenile accused and confirmed the conviction. Supreme Court, after elaborately discussing various aspects of evidence act and other provisions of the CRPC, intervened with the judgment and acquitted him on so many reasons. This is AR 2025, Supreme Court 2996, AR 2025, Supreme Court 2996, Vaibhav versus State of Maharashtra. The deceased and the A1 were homeopathy college students, first year students, were friends. On the fateful day, as usual, the deceased joined with the accused one. Unfortunately, according to A1, he took a gun of his father, which was kept inside the bed cover somewhere, aimed at him, unfortunately, accidentally triggered that went to the skull of the deceased. And according to evidence, the part of the trigger after coming out of the skull of the deceased attacked the ventilator, which was a little bit height. So the other evidences are there. Thereafter, he seems to have took the help of juvenile accused and cleaned the bloods and tried to conceal the body. Therefore, all these things are there. The Supreme Court, what they say, see the area of evidence which says the reaching ventilator, which was significantly height, so there was no possibility unless and until the deceased was sitting and looking downwards towards barrel of pistol from a close distance. So there is all these things are there. But the main ground that when the accused had taken a specific defense before both, that was not examined at all by the trial court, blindly convicted him. That's what they say. Thereafter they say there was no ill will between them. Even the father of the deceased did not say anything. The grudge against the A1, grudge against the deceased with the A1, no criminal background. All these things are considered 2010 matter. The conviction, the judgment was 4/6/2025. The accused was acquitted. And it is for you to go through the entirety of judgment, understand the discussion under what circumstances the Supreme Court expect the lower court to look into the defense of the accused. So the guilt was set aside and he was acquitted from the charge 302 read with 5 of the read with 25(1)(a) of the Arms Act, 25(1)(a) Arms Act, so many things, 201 IPs, all these things you can very well go through the entirety of judgment. So the another aspect Supreme Court was said that the burden of prosecution and accused about evidentiary value says that the prosecution must adduce evidence to prove the case beyond all reasonable doubt. So far accused is concerned, preponderance of probability may be applied. Therefore, they say the defense of the accused that it was accidental fire are to have been considered by the lower court. This is what Supreme Court says. Best wishes.